So today I'm talking with Celia Rivera, and Celia is an attorney who works with personal injury and often works with massage therapists and other types of healthcare providers. And we're going to be asking some questions about how we as therapists can work with our clients and help them a bit. But often massage therapists, chiropractors, and PTs and such think they know the law, and the laws obviously change from time to time, but we want to get some insight. So the first thing to do is obviously find an attorney to speak with, but maybe you can help us with that, Celia, and tell us more about what's the best way to find an attorney.
I think it's important for clients to get an attorney early on. The insurance company is definitely not looking out for their best interest.
Right.
And especially early in the beginning, they may want a recorded statement. I don't necessarily think that's a good idea. I don't think everybody needs an attorney, but I definitely think everybody would benefit from at least getting a free consultation, making sure they know what their rights are.
Right.
There is a 3-year statute of limitations, but it's a terrible idea to wait for 3 years.
Right.
You should come in as soon as you can.
Right.
And most attorneys that do what I do offer a free consultation.
Okay. So they should probably ask around, find out who's good at what they do, and not just look at the Yellow Pages or the web and find someone.
I think a lot of the chiropractors and therapists in town probably have some experience working with some attorneys. I would definitely encourage therapists to get to know some of the attorneys that they enjoy working with better. I guess the one recommendation that I would make is that definitely should be an attorney that only does personal injury.
Right.
And there are some guys out there who kind of like to dabble. It used to be a long time ago we had general practitioners.
Right.
That's probably not a good idea. You want somebody who probably exclusively focuses in doing personal injury because they're very knowledgeable about it. But with that, there's probably a caveat. There are definitely firms that are really big, and the primary contact that you want to have with that firm is with the attorney, not necessarily a legal assistant.
Right. Okay. Yeah, I think it's important to know really also is that when you have insurance, have your car insurance, and you think that when you're dealing with your insurance company that they're trying to help you, and if you have PIP, that person who's in charge of the PIP portion actually is helping you, but there's a part of that insurance company that's actually kind of your adversary in a way, isn't it? That you're actually have the part that pays your bills, but if you have PIP, that they have a person in charge of finding a way to minimize what you receive in that. How does that work?
Well, it's a funny thing. Insurance companies sell a lot of different coverage, and PIP is usually coverage that they sell. That's not where they really make all their money. Our insurance commissioner is awesome. He basically tells them they have to sell it to us. And in order to not sell it, they actually have to get a written waiver to say that you've actually rejected it. Keeping that in mind, that's what makes it a little bit difficult for them to kind of switch hats.
Right.
But because they're your insurance company, they should have your best interests at heart. And I
Right.
say that theoretically, but sometimes it's hard for them to turn off that economic benefit.
Right.
And
Got it. So just to be clear, Celia is a Washington State attorney, and you may be watching this from Washington State. You might be watching this nationally, and of course, just talk to your local attorneys and find out what may be the law in your area. But Washington State is a very consumer-friendly, consumer-protective state,
Yes.
and so we have some great laws here. But it may be different where you're at if you are watching this from a national perspective. If you're advised a brand new therapist or looking at perhaps, or maybe they've been doing this for a while, but they want to get involved with PI cases, is there anything that you think that massage therapists or healthcare providers should know when it comes to working and dabbling in PI work? They're not really sure how to proceed. What things have you seen massage therapists must know?
Well, definitely, and hopefully this is covered in school, but definitely your records are number one key, important, following the SOAP note format, and kind of stick to the facts. I mean, definitely, I don't know if some therapists, when they're doing relaxation massage, sometimes they don't always keep notes, but
Right.
if they've been involved in a motor vehicle accident, it's absolutely 100% imperative that you keep notes.
Right. Whether they say they're actually filing a lawsuit or not, still keep those records because they may change their mind later or say, oh, by the way, yeah, I guess I need my attorney wants notes, and you don't have any.
And sometimes you may have been treating somebody for relaxation, and if you forget to ask them, hey, what's going on, anything new, or you notice that their body is out of whack, you should probably ask what what's going on? And they may say, oh, yeah, I forgot to tell you since I was just coming in here anyways. I got in a motor vehicle accident.
Right.
So if you don't have those chart notes, it's really difficult for us to, it's not advisable to recreate chart notes later.
Right.
They should be made contemporaneously that day, shortly thereafter.
Right. And realize too, obviously when you're talking to your massage therapist, that person should not be writing down personal information. So as a therapist, be aware that whatever you dabble in your notes, whatever you say to remind yourself about the future, that can become legal record. And whether even if that client emails you, the emails can become, you can subpoena those and actually require those to be given. So if you're putting personal information in there, just be aware that might be showing up in a court someday.
Yeah, and saying that, I mean, that's a good reminder. Some things aren't necessarily relevant. Like if somebody's going through a divorce, patient seems unusually stressed, aggravating symptoms because she's going through a divorce. That actually just gives the insurance company, PIP, in particular, say, well, it's not related to the accident. I mean, the only reason she's in here is because she's going through a divorce. It has nothing to do with the injury. I mean, that's crazy. I mean, we all know that, yes, stress can aggravate some things, but those notes, that's not necessarily going to help the cause.
Exactly. And I've seen, I won't go through all the details, I've seen some horrible people out there who've really taken people's personal lives and just smeared it in the courtroom, and it's not right. So, what advice when it comes to billing? I know there's a number of different aspects. So, if a person comes to you and they have health care in Washington State, for example, and they're able to have the health care pay for massage, the person comes in. We obviously have what we call a cash price. Never have a cash price. Always have maybe a same-day payment price as well as a billing price. So if the person wants to pay you later, regardless of how it's paid, it'll be a different price. But don't say cash. It's problematic. But
well, the insurance companies feel like they want the cash price
they do,
too.
Exactly. Yeah. So you want to, they pay you in cash, but they want to so have a same-day payment perhaps price. But regardless, if we contract with an insurance company, let's just say our rate is, just for simpleness, $100, and we've contracted with a company for $50, a reduced rate. When I go to bill this to the person's PIP policy, but I also have them as a healthcare client, how do you navigate that?
So really, that's actually a really good question, and I definitely know this is a law in Washington. It may be different in other states, but I don't think so. The insurance follows the vehicle. So if a person whose ever vehicle they were in, whether it was their vehicle or they were a passenger in somebody else's vehicle and they got a motor vehicle accident, the first coverage is the PIP for that vehicle.
Okay.
And so that's who you bill first. PIP is a great thing if you therapists aren't familiar with it because it pays 100% of the bill. So if you charge $100 for massage, they pay $100.
Right.
Once PIP is exhausted, and it can sometimes
because
be quickly.
Typically they have a certain amount of money, like $10,000.
Yeah, in Washington it's $10,000. I strongly recommend everybody have as high as they can buy it. Usually it's like $5 more a year to have like a $35,000 PIP.
Right.
So when clients come see me and I see how much they have, I usually give them that talk about really it's only like $5 or $10 more. You need to up your limits.
Right.
Because the ER is getting really smart and they like that PIP too. And so they'll usually bill the PIP, and so sometimes that can be used up.
And you add ambulance rides and maybe a helicopter ride.
A hospital ride. If somebody decides to, you've got PIP, maybe we should do an MRI, out of the box or something. And, and that PIP, that $10,000 can go really quick. And sometimes there can be double layers of PIP. So if you're a passenger in somebody else's vehicle, their PIP pays first. And then if you have your own insurance policy, even though your vehicle wasn't involved in the collision at all, your insurance will cover as well.
Okay.
Once that is exhausted, then your health care insurance comes into play. And if your client has health care insurance and you're a contracted provider with them, you absolutely have to bill that insurance company.
Right.
So even though before this motor vehicle accident, you were billing health care, that stops. You bill PIP, exhaust the PIP, and then bill health care again.
Right. So I think what Celia's saying is that you can't, let's use $100 for simple. It's $50 contracted prior, it's $100 during PIP. When that's exhausted, we go back to billing the health insurance company. But we can't say, I'm not going to bill them. I'm just going to add up this money, watch it grow and
Right.
grow and grow, and then bill them when the whole thing
Right.
settles. You actually have to start to.
You absolutely do. And really, PIP pays $100 because that's what the contract says.
Right.
Right? And you don't have to be contracted, but it's contracted with your patient. And then if all you get is $50 for the contracted rate, say with Regions or whatever the insurance carrier is, that's all you can charge, and you have to write off the difference.
Right.
Whatever your contracted write-off is, as you would have before the accident. There's no law that says it's different if there's a motor vehicle accident.
Right. So next question comes down to, massage therapists. Oftentimes they are afraid to charge too much, or but they have insurance, they want to charge more. How do you find out whatever your healthcare provider you are? How do you find out what's reasonable for your area? I know Seattle, for example, is considered a higher market and a different price than perhaps a smaller city. So, is there a way for therapists to find that out? What's reasonable rates for their area?
That is definitely a difficult question. A lot of people, for this area that we're in now, I definitely see, like, if it's a same day payment price, it's $65, but I've seen it as high as $170 for an hour massage.
Right.
And the problem is when you see that kind of disparity and that discrepancy, it really makes proving that amount is reasonable and necessary and related very difficult.
Right.
It's probably somewhere in the middle. Regents, definitely there's a contracted rate, but that's a discounted rate, so that really
Right.
wouldn't be your billing rate.
Right. I think this is a semantics as well, but some therapists I've heard of have offer everybody myotherapy, and they only charge insurance company for a massage. So when they come into their office and they charge you $65 for myotherapy, but when insurance is involved, we're going to bill for massage, and that's a different rate. And so they're legally kind of sidestepping that amount because they're saying, hey, it's something different.
Right.
And so when you're calling something massage for relaxation and something massage for injury, unless you charge your cash paying clients two different rates,
Right.
then you really can't justify it.
You can't. And the problem is more often than not, it's not the therapist, the massage therapist that's on the stand, it's your client. They'll say, well, didn't you get massage before? Well, yes. And
What
did
was
you get
the
massage
rate?
after?
Right.
Yes. And what was the rate? And was the treatment different? And if the answer is no, she pretty much does the same thing,
Right.
we're never going to get that, because who's deciding it is a jury. And a jury's going to say,
Right.
I would never pay $170 for an hour. But on the other hand, 65 is really low.
Right.
I think something in between. I think probably the best way would be to talk to the attorneys that see a ton of medical records. We see the range, and they can usually tell you what kind of a midpoint is and what usually never causes problems.
Right. From a healthcare standpoint, if someone is a preferred provider for a healthcare company, that they tell them you can bill these codes, like 97124 for massage, for example. But are there codes, when it comes to a legal standpoint, if you're not contracted, that we can or cannot bill for? Have you seen any problems with billing codes when it comes to the law?
Not really. From the reality is that our jurors have no billing code experience,
Right.
and so it's kind of two different perspectives. If we're talking about what is an arbitrator going to rule, or a judge is going to rule, or what a jury is going to rule, they have no idea what the codes are. All they know is what the massage is. This is the standard code. If you bill something else that has like a physical therapy component, you just need to be prepared to articulate how yours is different.
Okay.
If you believe that justifies a higher charge. And in many cases that may, but you need to be able to justify that. And
Right.
definitely there's clients will talk about the different types of massages and how they feel differently to justify those type of codes.
Right, because we can do neuromuscular reeducation and manual therapy, and some people say, well, only physical therapists can pay, do provide that specifically, or myofascial release. There's different codes for that. So just check with the probably your attorney that's working with your client, perhaps, to be friendly enough to find out what's normal and fair and reasonable, because you don't want to be embarrassed later on to find out you've been billing the wrong thing entirely.
Correct.
The next subject I want to ask you about is liens. I know that when you have somebody who gets in a car accident, there's no insurance involved, and you're going to have to wait a while for recovery of that. And hopefully, I've seen people who've actually filed bankruptcy. Never got paid, or
Yes.
they got no settlement at all, and there's no money to
Right.
pay the bill. But if there's a settlement, obviously I want my portion of
Correct.
that. And one of our devices that we can use legally is a lien. Can you explain how that works?
Yes, there's definitely two different forms. I mean, if a client comes in and their PIP is exhausted or they have no health care or, that's exhausted because there's
Right.
only 10 visits or whatever, definitely you should have them sign a contract that says that they're agreeing to pay you when this case settles. So that's one aspect because that actually gives you legal authority to sue on that contractual basis.
Right.
And then second, there's a lien, and it's a standard form. You basically file it with the local county. You should probably update that at some point. It needs to be renewed every year. And then once you get paid, you basically have to make sure you release the lien because that actually kind of shows up on their credit on some level.
Okay.
But definitely probably the most important part is if you file the lien, you need to make sure you give a copy of that lien to the insurance company that you think is going to pay you, which is the third party, or the attorney.
Right.
So if you're working with an attorney that you like, that you trust, that you have a good relationship with, you don't necessarily need to file it with the insurance company, but you absolutely have to file it and give it to the attorney.
He needs to be aware. She needs to be aware.
Yeah, because there's no requirement for the insurance companies to go call up and find out if there's any liens filed anywhere. That's just not going to happen.
Right.
And nor is it the attorney's responsibility. Hopefully you're working with a good firm. We always call our providers and double check what's the current balance, what are you owed, have you been paid, and then at that point it'd be nice to say yes, you have a lien. It also protects you against clients who get a little greedy at the end and they're like, well, I don't know if I want to pay all that.
Right. So again, especially if you're not really familiar with the attorney, or maybe you are, and someone that you're not really enjoy working with, if you do get that lien filed, when you send that copy, send it through registered mail. Have a way to have proof that they were dropped, or certified mail that for sure they received that. And call them and make sure that you remind them and let people be aware of that. But I've had the experience once where I had the lien filed, the attorney was aware of it, and they still didn't pay me. They paid the person who was receiving the money, and I didn't get paid. What recourse do we have as therapists if we have someone we're working with who's not really full of integrity?
I can't believe that happened, but that actually opens the attorney up to suit because I definitely have had clients where they're like, well, do we have to pay the therapist? And I'm like, actually, yes, you do, because there's a lien and I'm subject to suit for violating this medical lien.
Right.
And so, no, you have to pay the therapist and we are going to pay the therapist. And so really it puts them in a good position. The simple fact that the lien was filed at all, I mean, that attorney is opening himself to suit.
Right. And what's important too is you don't surprise the attorney at the very end and keep the bills private until the very, very end. Oh, by the way, you owe me $10,000, because that attorney, as they're negotiating that settlement, needs to have in mind all the different expenses, all the costs involved, all the providers, have an idea of what that bill looks like, and plus, the more bills that attorney has, the larger the settlement perhaps is going to happen anyway, because it's related. If there's only $1,000 in medical bills versus $100,000, the court obviously looks at that and says, well, maybe there's more need.
Now that you mention that, it's actually a good point to bring up. And in my experience, if you go to the ER, you always get a bill 30 days later.
Right.
Where what we don't often see is therapists, well, we're just going to file a lien and we'll just send one big bill at the end.
Right.
When there's PIP, you want to get paid. I strongly, strongly recommend that you bill PIP within the 30 days of the treatment.
Right.
And if there's health care, you should be doing the same thing. And then there's like rules in place, like you have to bill within the first year.
Right.
But when you're holding the balance, sometimes therapists think, well, we'll just worry about it at the end. The problem is the attorney really has no idea sometimes how serious the injury are or what type of medical bills are happening. It would be a good idea in a perfect world to just go ahead and send the bill when you send the bill for everyone else. But at a minimum, maybe every 3 months, just print off a bill and say FYI, just so that the client's still treating. This is what we owed today. It really does protect you if there's a problem or if the client's doing something that you're not aware of.
Right. And that balance, in Washington state law anyway, and other states is often the same. You're able to accrue interest on that balance. And so if you have that, make sure it's A, on the intake form, B, on the contract with the client, and C, the attorney's aware of that as well. So if it does take 3 years to get paid, well, that's a significant change in that balance.
Right. And it does help us educate our clients. Like, really, the therapist is doing you a favor. They don't have to wait. And so they are entitled to the interest, and it kind of helps soften that blow when they're expecting it.
Right. I've had several clinics myself over the years, and I think it's important for massage therapists specifically. We're kind of working often with a referral from a doctor, a medical doctor, naturopath, chiropractor, and they're referring to us, but to have a team mentality. So when that person gets in the accident, immediately I'm talking, saying, you know what, you need to talk to an attorney, make sure that they tell you what not to do, not to throw your case off by talking to the wrong insurance person. Get a chiropractor involved to get a referral for these treatments and such. So where does the attorney fit into that mix of working with that team, and what's important for the therapist to know?
I think it's important that, from my office in particular, we try to really encourage that team mentality. So when we have a client that comes in and they tell us who they're treating with, we usually send out a letter and say, hello, we are now representing, your patient. If you have any questions, please give us a call. If you have any concerns, please give us a call because we'd like to discuss that with you.
Right.
And I think that's really important. And definitely as the therapist reaching out to the doctor, I think periodically, if in my opinion, the chiropractor or the referring doctor should be requesting those chart notes to see kind of how that treatment's progressing. I think that's really helpful from a legal standpoint when the doctor is saying, yes, let's have 12 more visits or let's have 16 more visits of massage, because they've actually reviewed the chart notes, they're seeing the progress,
right.
They're seeing what you're finding. If you have a doctor who's not willing to renew a referral, for example, you could probably give them a call and say, hey, I want to talk to you about this patient. This is kind of what I'm finding. What do you think? Do you have any other recommendations?
Right.
And that will help that as well.
On the first visit, I've mentioned this in my seminars on injury treatment, but that patient comes in and says, I got in a car accident, my neck hurts. Well, the doctor writes a prescription saying massage the neck. Mm-hmm. Obviously, their hips probably got hurt. They have issues in their back, but they just don't feel it yet because it hasn't revealed through gait theory and other things. But as we relieve their neck, well, now the back hurts, and so now we're massaging the back. Or you take it upon yourself to start massaging all those areas, even though the prescription says just massage the neck. And the problem is that if you're massaging other parts of the body, even though it's necessary, without that prescription as a backup, we're going to have problems. So what I typically tell my therapists I work with is to go ahead on the first visit. If that prescription says neck, I write a report saying I palpated the rest of the body, found these areas to be involved. Is that helpful?
I think that's a great idea. And I think it's even more important when your patient is not seeing a chiropractor in particular, because most MDs just really don't focus on the mechanics of the body, and they're just, oh, well, it hurts, so go see a massage therapist or go see a physical therapist and then check back in 6 weeks or 2 months. And you really want them to check back, but a lot could have happened in between then.
Do you know, so if a therapist has a client come in, I got in an accident yesterday, and they start to massage without a prescription in place. I'm not talking about medical insurance, but actually just PIP. If a person has a PIP policy, does that require to have a prescription, or can the insurance company force you to have one?
No, not at all. So whether or not there's PIP, if you had no insurance whatsoever, definitely a person can go in and just self-refer anywhere they want, including massage. It's definitely more beneficial if you have a treating provider, say a doctor or a chiropractor or a naturopath or somebody else that's actually saying, yeah, I think that's a good idea, and yes, it's reasonable, necessary, because the problem is, in Washington at least, the therapist cannot diagnose.
Right.
And so, it's, again, because you're, depending on who your audience is, if it's an insurance claim with PIP is going to be all upset because, well, why did they do this? The reality, it comes down, is it reasonable and necessary? So even if there wasn't a referral, if a doctor evaluated them and said, well, it would have been reasonable and necessary anyways to have massage, we'll usually be able to get it paid, but it's a technicality. So it is better to have somebody who's referring it, but it's not absolute. And if somebody comes in, you should just treat them, and we'll figure out how to get it paid.
And we can obviously point the obvious out. I mean, we don't have to have a referral to say the person has hip pain, but if we say that it causes this kind of pain to turn to the right, we can make notes specifically about that, not say, oh, they have whiplash or they have thoracic outlet syndrome. But we can say we found as far as the description of that.
Yeah, that's a burning, stabbing,
Right.
left, right, totally. Yes, those
Great.
are all excellent.
Excellent. Well, Celia's been quite a bit of help. If you have any questions, we're going to leave Celia's information on here as well for you to contact. But find a good attorney, work with one, ask questions before your client needs an attorney, not when it's too late. But have that team put together so you're working as a team with your attorneys, not just after the fact. So thank you very much.
Couldn't agree more. Thank you
All
for
right.
having me.